Hi everyone, and welcome to video 3.2.4 for the Legal Studies guy, looking at methods of resolving disputes today. But as always, jumping into a quote from the famous martial artist and film star Bruce Lee. The successful warrior is the average man with laser-like focus. Just that reminder again to have clear direction with what you're doing. Have a clear focus, a goal that you're working towards, and that's what's going to elevate you above the average student to actually have your eye on the prize, if that makes sense. So 3.2.4 today, and the listing of the key knowledge point, the wording is the purposes and appropriateness of methods used to resolve disputes, including mediation, conciliation, and arbitration. So again, clear language, we're referring to these three things as methods, and it includes mediation, conciliation, and arbitration. Including showing that they're not the only ways that we can resolve disputes. And that's really, really important. Parties in a civil matter can resolve disputes through an agreement that doesn't come from these three methods. So they could resolve a matter through agreement, through correspondence passing between their lawyers, for example, that isn't using a formal method like mediation, conciliation, or arbitration. They can resolve it through a trial, obviously. They can resolve it through a hearing at VCAT. So those are also other types of methods that can be used to resolve disputes, but we will focus on the three that are listed: mediation, conciliation, and arbitration, and loosely what they are. The key skill is going to be a discussion on their appropriateness. So when they are and when they aren't appropriate. So those two sides, or I guess the features of a dispute that would make them appropriate versus the features of a dispute that would make them not appropriate. And effectively, the question's going to be, what methods can we use to resolve civil disputes, and what cases will they work for? When will they be appropriate? So three methods listed will be the three that we focus on. First up is mediation. Now, mediation is a word that you've hopefully heard before. You might hear people talking about, mediating something or being a mediator. And it's just that effectively that idea of that third party stepping in to try and help the parties through process, not through ideas in a legal sense, but help the parties to come to their own agreement, to be that facilitator so that the parties can hopefully come together and figure out their dispute. So the key thing with mediation in terms of what it is it's all about cooperative manner. So the aim of mediation is to resolve disputes cooperatively, meaning the parties coming together and working on a solution. There are generally strict rules of procedure in mediation. So you'll hear a lot of people describe mediation as like the most, it's an informal way of resolving disputes, which is true. Mediation is much less formal than a court hearing with strict rules, witnesses, potentially an optional jury, a judge sitting up on high. So it's much less formal than that. But it is worth noting that mediation is not loose. Okay, there's not an absence of rules where parties are just getting in a room and kind of like shouting at each other. The way mediation is run in a formal mediation is with really strict rules of procedure. And generally speaking, this is a bit of a funny cartoon in the sense of the parties won't even look at each other, hence why Judith is sensing that it will take more than half a day to resolve. But generally speaking, how mediation will work is that the mediator will sit at the head of the table and parties will come in and sit on either side. And in terms of strict process, parties will first have a chance to, in an uninterrupted way, so the other party, this is where the mediator controls things, the other party is not allowed to interject. They're able to basically run through how they view the issue. So that could include how they feel about it, what their values are, what they believe the main issues are. It's not about strict rules of evidence and evidence being tested. That can come up in what the parties are saying. But it's much more a space for parties to sit at a table and put forward their view so that the other party can hear. And once they're finished, they have had an uninterrupted chance to put forward their view. The other party will then do the same. What generally then will happen in a mediation is the parties will separate. The mediator will speak with both parties separately. The mediator will effectively try and, based on what both parties have said, summarize and really highlight what the key problems are, where the parties are different on things. And then the parties will start getting a chance to come up with solutions. So mediation, the important thing is the mediator does not interfere, make a decision, or suggest resolutions. The parties come up with their own solutions, and the mediator effectively acts to pass those back and forth between the parties. Now, that could happen with everyone in the room together. What is more commonly going to happen in, say, judicially ordered mediation, particularly between businesses, is that the parties will be in separate rooms and the mediator will move between the parties. And effectively, the parties are coming up with offers to the other party. Hey, maybe if we do this, would you be willing to do this? What that means is the parties can come up with a decision that hopefully suits them both in a way. They're both able to maybe get something out of the outcome, as opposed to going through a whole process, a whole civil process, going to court and having a binding decision handed down by a judge in the favour of one party or the other. Mediation, much more helpful for both parties, and it's also private and confidential. So really important, perhaps, for famous individuals, businesses, companies who would like things resolved and would like to move on without there being a lot of publicity around it, like an open courtroom. So when is something like mediation, when is that kind of approach going to be appropriate? Well, the features of, I guess, fictional case studies or even real case studies that you're going to be looking for, you're effectively going to be looking for parties that are willing to cooperate. So you want parties that are willing to attend. You want parties that have shown a willingness to resolve the dispute. So there's not a lot of animosity and friction between the two groups. Often you want to be looking for parties that have a future relationship in mind. So neighbours, family members, etc. Parental disputes come under that banner as well, because a really big aspect of this is if we can come to an agreement, then we've in a way cooperated on that. It preserves that relationship. There's not that I win, you lose outcome that you might get if you go all the way to court and have a trial. There must be a willingness to compromise. So you'll often see language in case studies around, someone is adamant they haven't done something wrong, or, not willing to meet or has not responded to. And they might be features where you could say, hey, based on that, mediation is not appropriate because that party has not shown a willingness. So you're really looking, again, like with all of those things, it's all centered around cooperation. In terms of appropriateness of mediation, you're looking for features of a dispute that illustrate people are willing to cooperate and come together. And that's that same with that last point. Also, mediation can be appropriate. This one can speak to its appropriateness as well. If you think one party might want that privacy and confidentiality. So mediation can be really appropriate if you want that. They're the main features of a scenario or a case that will make it appropriate for resolution through mediation. Now, a common thing I just want to be crystal clear on is some people will make the mistake that because mediation is the least formal dispute resolution method, some people will then equate that to it's only suitable for less important or less formal matters. That's wholly false and an inaccuracy. Mediation often helps us resolve the most complex and the most serious civil matters worth the most money. In fact, often a really complex, contract dispute between a business or a really complex class action, say around, like a bushfires class action from 10 odd or 15 odd years ago. In a way, mediation is actually more appropriate than going to trial for those really complex matters, because the parties know the matters better than anyone else. Like, the parties are more heavily involved. It should almost, in a way, be a decision coming from the parties coming together. So just be mindful of not making that mistake. Really complex and serious civil matters are absolutely appropriate for mediation, and that's not a factor that should come into considering its appropriateness. Our second method is conciliation, and I can move through conciliation pretty quickly because conciliation is really, really similar to mediation. Like, you'll see here, aim of mediation is to resolve disputes in a cooperative manner. Aim of conciliation is to resolve disputes in a cooperative manner. No rules about evidence. Parties discuss feelings, etc., etc. Strict rules of procedure, but no rules about evidence. So conciliation is effectively really similar to mediation. There's usually strong processes involved. Conciliation or conciliatory approaches are often used in things like case conferences, in the pre-trial process of a civil dispute that's been initiated through the courts. Some conciliation will be used through VCAT. CAV, which we'll learn about, it's a body that uses a conciliatory approach. And effectively, it's like mediation. It's like parties are coming up with potential solutions. Parties are getting a chance to express their views or how they see the civil issue. But unlike a mediator, the conciliator will offer advice and suggest possible resolutions. So the conciliator will actually hear from both parties, and that's a really, really important thing. Like, both parties are heard, both parties have a chance to speak in an uninterrupted way, and then the conciliator will offer suggestions, offer responses. Suggest to the parties, hey, based on what I'm hearing, you could maybe do this or you could do this. It's private and confidential again, which is going to speak to its appropriateness for some matters. Really good example of, a conciliatory approach is that CAV, Consumer Affairs Victoria, which you'll learn about as an institution to resolve disputes later in this area of study. But that's a great one where, Consumer Affairs Victoria are experts in consumer law. To get a job there as a conciliator, you have to understand Australian consumer law and be an expert in it. And if an individual has an issue with a business based around consumer law, refunds, returns, something like that, the business is saying that, they're refusing to allow a return or whatever it is, it can actually really help to have that body, CAV, as a conciliator, as an expert, saying to the business, hey, this is your legal obligation. Like, our suggestion is that you give them a refund, or our suggestion is that you give them a return. And that can actually significantly help resolve disputes without needing, again, to end up down at a VCAT hearing or a court trial for something that is potentially relatively minor. When is it appropriate? Obviously, we're shaking here and getting to a resolution. It's got incredibly similar appropriateness features to mediation, because they are incredibly similar dispute resolution methods. It is all around cooperation. Willing to compromise, future relationship in mind, looking for a win-win, open, listening to the other party, willing to attend. Generally speaking, parties can't be forced into mediation or conciliation. There can be some court-ordered mediation that parties might have to attend, but in terms of actually engaging and looking for a resolution, can't be forced on parties. The resolution has to come from them. Even in conciliation, they're getting suggestions, but the decision, the resolution, the compromise has to come from the parties. So if they're not willing, then it's not going to be appropriate. And again, privacy, confidential, can be really, really important in that space. Now, I want to highlight as we get to arbitration that there is like a real shift here in that mediation and conciliation are really, really similar. And, we might say that they're less formal, even though there are some quite strict rules. And if we then have that line through to if we have that line through to more formal, and obviously our most formal way of resolving disputes is a trial, going to court and actually having a trial. Arbitration is much more down this end towards it has some really similar features to a trial, as opposed to being really, really similar to mediation and conciliation. So it has more similarities with a trial. It is a much more adversarial dispute resolution process or method than mediation and conciliation, which obviously we know are much more cooperative. So arbitration. And I have included Judge Judy here for a really, really clear purpose, because Judge Judy is actually an arbitrator. So she should actually be called Arbitrator Judy, but obviously alliteration not as good on her name if we call her Arbitrator Judy. Judge Judy is a perfect example of arbitration. She's dressed up like a judge. She used to be a judge. It's sold as her being a judge, but it is not a courtroom. It's not a feature or a part of the judiciary system, I think, in New York or wherever it's filmed. It is a extrajudicial process where the parties who go on Judge Judy sign a contract. They sign a contract saying that they are going to go on and they are going to abide by the decision handed down by the arbitrator, by Judy. Judge Judy, if you've ever watched it, is a great example of arbitration. So the arbitrator is the decision maker. That's the really, really important point. So the arbitrator is the decision maker. They will make a legally binding decision. So the arbitrator is the decision maker. Unlike mediation and conciliation, where the parties are the decision makers. So you're starting to see those similarities there with trial. Generally speaking, arbitration will have a lack of formal, consistent rules of evidence and procedure. The arbitrator and whoever handles the arbitration, be it a professional arbitration centre like the Melbourne Arbitration Centre, I think it's called, which I've got a link to later on, or whether it's an independent arbitrator that you agree with the other party to bring in, the arbitrator will decide how the dispute's handled. They'll decide the rules. As you would see if you ever watch an episode of Judge Judy, there will be evidence presented. People will bring in documents and they will ask questions, but the arbitrator will also ask the parties questions. And the arbitrator will, the parties might speak in different orders at different times, and the arbitrator might ask them questions directly. They might bring a witness in. The arbitrator might ask the witness questions. Ultimately, how the arbitration occurs is up to the arbitrator, which suits some parties and makes it appropriate because they have, particularly as part of a contract process, they have greater control over the rules and therefore potentially greater control over the outcome. It's really important to note that the decision in arbitration is legally binding because, again, generally the parties have signed a contract. Okay, so usually the parties have signed a contract that says if we have a dispute, we will go to arbitration instead of court, and we agree to follow the decision of the arbitrator. So I can't stress that enough. Arbitration, like mediation and conciliation, is private and confidential. Okay? And that's another really important point. And it's why it's so widely used by businesses, because we know any publicity is not necessarily good publicity. Often publicity for businesses is bad, particularly if they're involved in a legal dispute. So they are much more likely to use a method like arbitration, where it is like a trial, where the arbitrator will hand down a decision, but they'll do it in a private and confidential setting with less stringent rules. So when is it appropriate? When a decision needs to be legally enforceable. Now, I will highlight with mediation and conciliation shortly that they are generally legally enforceable as well, the result of mediation and conciliation. But it is fundamentally a good point about arbitration, is that arbitration ends in a legally enforceable decision. If the parties haven't been able to come to an agreement using other methods, so mediation and conciliation have failed, for example, or mediation or conciliation, it's unlikely that both would have been used, then you might need to use an arbitration, or the parties might agree to go to arbitration before going to, initiating, or rather than initiating a trial. If there's sort of a history of animosity or broken promises between the parties, it's really, really common for disputes between businesses. Like, I want to make sure we're clear on that. Generally, again speaking, that'll be a feature of a contract between businesses. I've agreed that I will supply you over the next 5 years with, 36 shipments of this particular product. And then I, for whatever reason, don't meet those shipments, but you've paid me, you are disputing that you should get, some portion of the money you've paid back. I'm refusing. We might go to the contract regarding those 36 shipments, and the contract might clearly say, if a dispute arises under this contract, the parties agree that they will go to the Melbourne Arbitration Centre for arbitration, which will be run by the Melbourne Arbitration Centre using these rules. So that will be how we resolve the dispute, rather than going to court, which is likely to cost more money and potentially lead to bad publicity for both our businesses. So that's why it's usually used for disputes between businesses. So a feature of a case study to look for. But also it means it's not actually accessible for everyone. And in fact, it can be pretty hard to get yourself arbitration as a private individual. The courts do run some arbitration. Magistrates Court does arbitration for matters under $10,000, and can order some further matters to arbitration. But in terms of you privately accessing a private arbitrator, that can be really, really expensive and hard to do, and generally speaking, not something an individual is able to do. So sort of bake that in or factor that into the appropriateness of arbitration. If it is a dispute perhaps between two individuals, they might be better served utilising other methods, or going to VCAT and going through that process. So our skill here, as I've just sort of gone through in quite a lot of depth, is the appropriateness of these methods. So we'll get to class actions and we'll get to institutions, but discuss the appropriateness of methods to resolve a civil dispute. And we know discuss means, as always, an exchange of opinions, which means we need to both go how these methods are appropriate, but also how or when they are not appropriate. So here is a pretty comprehensive list. Now, what I've done here is I've just basically tied up all of mediation, conciliation, and arbitration on this side, because they are all alternative methods and they do have some features, some common features that make them better or more appropriate than going to trial or going through I wouldn't say going through a court process, because courts often use mediation, but they do have some common features. They are generally more time efficient. Disputes are often resolved faster. They are generally cheaper. Often you don't need, and don't use absolutes here, often in mediation and conciliation, or even arbitration, you don't need a lawyer. So because there is such a relaxing of perhaps some of the rules around evidence particularly, you can speak more openly about your thoughts and feelings. And there is someone there to guide you through that. So if you don't need a lawyer or you don't need legal representation, it might not cost you as much. Businesses are going to use lawyers in mediation and conciliation. Just being clear on that. But for individuals particularly, might be significantly cheaper, also because it is generally significantly quicker. So those two tie together. Parties might feel more comfortable using these alternative methods, even arbitration, because of that lower level of formality than the courts. Not having all the costumes and the wigs, and even though wigs aren't used much anymore, and the judge sitting up on high. It is about mutually agreeable outcomes. Having control over the outcome is generally preferable, as opposed to leaving it up to someone to basically hand down a winner and a loser. So mediation is incredibly successful at resolving disputes between businesses, for example, because businesses like to have control over the outcome, even if it means they have to give a little bit up. And it's also more likely then that if you agree to the decision, it's more likely that you're going to follow it, which is an important aspect of enforceability. And really, again, can't stress this enough, appropriate for civil disputes of all sizes. They can be especially good, particularly mediation in particular, for really complex matters. Just be careful with this point. Decisions made in mediation and conciliation aren't in and of themselves legally binding. So just be really careful, though, because parties will generally sign an agreement at the end of mediation and conciliation. They'll come up with their resolution and then they'll sign a binding contract. That contract is then enforceable, although that might need to be taken through the courts to enforce, which takes time and money. So there is an aspect of, not appropriate in their lack of a legally binding decision. But you should make sure that you explain that in the context of they are likely to sign a deed of settlement or terms of settlement, which is a binding contract. But yeah, that could still lead to disputes ending up in court. Or if these alternative methods fail, you might end up in court, and it adds another step, which is extra time, so an extra delay, which means extra cost. Some people need the rules of evidence, particularly if there's power imbalance. It can be better to have really strict rules of evidence and procedure. So there might be some matters where it's not appropriate based on power imbalance and the lack of formality, which those 2 points really go together. And a lot of people don't necessarily know about them, people get fixated on wanting to have their day in court, and maybe due to the prominence of that or how much people understand that, alternative methods might not be available or used as much because people don't see it as a viable alternative, just perception of. I should also point in inappropriate. Private is a really important point with them. We have to start tying everything into fairness, equality, and access again. And like always, there's going to be a strong focus on time and money. It reduces costs if you're able to resolve disputes cooperatively. You might not be able to use lawyers. Both parties have to agree so they're on the same footing. There's strong processes for equality. And parties can actually come to a decision that benefits them both, which is really fair. It's really just. But yeah, the limited rules of evidence could be an issue with fairness. Power imbalances could lead to an unjust outcome as well, particularly if one party compromises too much. Power imbalances are also fundamentally a disadvantage or disparity, which is equality. And that lack of access to arbitration for private individuals is very much a negative for that principle. In terms of applying these skills to real or hypothetical scenarios, as I said, common case study section B stuff around mediation, arbitration, conciliation, and being able to pick up features of a scenario case study and apply that to the appropriate, not appropriate. But if you do want to do a little bit of extra reading, Disputes Vic is really good at just outline some of the different approaches and methods that you can take, as they're trying to stream matters away from the court system. VCAT really heavily uses alternative methods, and they've got this lovely little section of their website around resolving a case by agreement, and basically how that process can work and the benefits of it. And this is the institution, organisation, business that I was referring to a few times, the Melbourne Commercial Arbitration and Mediation Hub, so MCAMH. They're effectively, a business in Melbourne that run a lot of commercial, so business arbitrations, and would undoubtedly feature in the contract of a lot of businesses who, where, as I said, it will say if a dispute arises under this contract, we will go to the Melbourne Commercial Arbitration and Mediation Hub. So you can get a little bit of an insight into, I guess, how an arbitration service works by checking out their website. If someone comes to you tomorrow with a civil dispute or a legal issue that they are dealing with, maybe it is one of the most common disputes in Victoria, such as fencing disputes. They want to build a fence and the neighbour doesn't, et cetera, and they say, how can I solve this? Like, do I need to sue them? You might be able to have a really good conversation with them after today about the fact that, well, not necessarily. There might be other methods that you can use, and there might be other institutions and providers out there who can support you to use those methods. So mediation, conciliation, arbitration, hopefully you could explain those to someone tomorrow, and as a result, you will be answering our essential question. As always, chuck us some feedback in the comments. Just let us know if the videos are of benefit to you, or if you're even making it this far, or just cutting through the middle section. But happy studying, and yeah, we'll get a video out on institutions.